The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon, and welcome to counsel and those watching on our Supreme Court Live channel. Would ask Mr. Doug Shima, the clerk of the appellate court, to please call the afternoon docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Monday, May 24th, 2021 consists of one case. Appeal number 90198, State of Kansas versus Jonathan D. Carr, Sedgwick County, briefs both sides. This case is scheduled for 60 minutes argument on both sides. The appellant has reserved 5 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
May it please the court, David Loudon, Special Appointed Prosecutor for the 18th Judicial District, Sedgwick County, Kansas, along with District Attorney Mark Bennett, who is off camera, and we are ready for argument, Your Honor.
May it please the court, Clayton Perkins, on behalf of the defendant appellant, Jonathan Carr, present and ready for argument.
Thank you, counsel. Just for the benefit of those who may be watching on our live stream, I will let you know that our plan is to recess after Mr. Carr's initial argument. We will take that recess for 15 minutes. Mr. Perkins, you can begin your argument.
Thank you, and may it please the court. In way of procedural background of this case is the companion case to the arguments this court already heard this morning. This court has previously affirmed 25 of Jonathan Carr's convictions, including a conviction for capital murder and first-degree murder, ensuring that Mr. Carr will serve at a minimum a life sentence. We are here on issues pertaining to the imposition of the death penalty. As a roadmap of where I'd like to get to in this argument, I'd like to start a little backwards by addressing what was P21, the cumulative error framework that this court employs, and particularly the impact at this stage of the reverse Batson error that this court has already found. I'd then like to address three interrelated issues involving P7, P8, and P17, which is confrontation, rebuttal, and closing argument error as it pertains to some of the expert testimony in this case. If there's time after that, I address some of the other instructional issues and some of the amicus briefing, but I'm not confident that I'll get to that point. Turning to the cumulative error analysis, this court has already found about a dozen errors between the guilt phase errors that carry over and the sentencing phase errors that this court has already addressed. And I am sort of, as the arguments were this morning, sort of assuming a law of the case application here to the holdings that this court has already had on previous issues and already addressed. And the scale of error in this case, it both involves a large number, but more importantly, qualitatively severe errors. And turning just to where we are in the cumulative error framework, this court has held in previous cases, that this framework is looking to whether the total cumulative errors had little, if any, likelihood of changing the jury's ultimate conclusion regarding the weight of the aggravating and mitigating circumstances, which is a different cumulative error question than this court addressed in the guilt phase proceedings, because this is looking to the distinction with the penalty phase and how the jury does this weighing process. The degree of certainty this court will, I believe, employ in this case is beyond a reasonable doubt, as there is constitutional error present here. We're actually dealing with, at a minimum, the same constitutional error that was present in the Cheever 2 opinion, where this court applied the beyond a reasonable doubt standard. And so we get to that same question. Turning specifically to the reverse Batson error, which I think is hasn't been addressed as much as some of the other numerous errors in this case. The question I think that this court is looking at in the impact of reverse Batson error to the penalty phase proceedings is a much more difficult decision than this court faced in the guilt phase proceeding, and I don't think it is something that the state can prove beyond a reasonable doubt did not impact the outcome of the case. And of course, part of that goes to just the what we're looking at in the penalty phase proceedings, that these are, this is a question of weighing that individual jurors do that is an outcome that doesn't require jury unanimity. So one juror being different functionally changes, who was looking at the decision and how they would. And a lot of those, that goes to a very sort of difficult question to even nail down as to how individual jurors would look at things. But in this case, particularly, we have a record here that is one, including our for-cause challenges to this juror, which we objected to him. We explained those bases. While this court affirmed that, this court also noted that that the questioning of this prospective juror yielded cause for concern, though that was not ultimately an abuse of discretion by the district court. But also in this context, this court noted that even in the voir dire process, this was an analysis that was, the review was clouded by the district court's and the prosecutor's use of leading questions to sort of guide jurors, including this one who eventually became the foreman of the jury, in sort of rehabilitating them. And that is, as we stated on the record at the peremptory challenge that was denied to us, we had several causes for concern with this juror's ability to look at the case, that they had weighed many of the statutory mitigating factors as actually would increase the likelihood of imposing the death penalty. And so I think that is, as this court noted in the guilt-phase cumulative error, it is an error that broadly affected the trial, and specifically to the penalty phase more severely.
Counsel, I'll jump in right there and just ask a clarifying question.
Yes.
I think you're utilizing the cumulative error framework, and we've had this law of the case issue throughout. Is it your position that have any of the penalty phase alleged errors been found to be errors in a law of the case right now, from your perspective?
Certainly, as I have prepared for this argument, I have assumed that where this court had a specific holding, such as I'll get to the P8 rebuttal that this court said was an abuse of discretion, that is.
That gets directly to my question, because arguably, at least, this court only reversed on 2 errors, which this court was then subsequently reversed on those 2 errors by the U.S. Supreme Court. And so, when this court entertained other issues but didn't actually enter holdings, are we bound by that discussion, which arguably is dicta? Does that question make sense?
Yes, I think that does make sense. And I think I understand the dicta argument. We are not, I guess, arguing against particular holdings for the purposes of this argument and the way we framed our supplemental brief. So like the issues involving our Section 9 challenges that this court said were moved, I'm still, at least at this point, assuming that holding was still the case.
Well, let's just take as an example, I think you called it the P8 issue, which is the denial of opportunity to present rebuttal testimony. Is that correct? Did
Yes.
I get that correct? Is it your view that this court already ruled on that issue?
Yes, as it said in Jonathan's opinion, which of course that opinion summarizes, but this court unanimously held that was an abuse of discretion. And turning to the expert issues, particularly P7, P8, and as that then factors into closing argument. So P7 is the confrontation right, the Crawford issue to the expert Dr. Pei providing the opinions of other doctors. That was objected to, but this is also Crawford was a intervening case in this analysis. So the first question is, does Crawford apply, which this court previously has said yes. And I would, relying on this court's analysis, rejecting the Williams v. New York argument there. So the second question that this court posited was, then does this present testimonial hearsay? And I would note that I have been unable to identify any point in the briefing of this case at which the state has argued that this is not testimonial hearsay. Diving into that question, I think this is clearly testimonial hearsay. That looks to the question for determining if something is testimonial hearsay, looks to the primary purpose test, which has been variously described as, was this a substitute for out-of-court testimony? Should the inquiry that seeks to identify statements that are by nature substituting for trial testimony, or whether or not the statements were made as for evidentiary purposes. And what we have here was one, as the record establishes, an expert who was involved in an ongoing criminal case. Their involvement started there, their analysis started there. We have statements on the record that he got involved with the case when he was told that they needed an expert to testify on scanning, on brain imaging. So we have that this is an entirely a process designed for establishing testimony that would come into the case. And of course, we have then experts who came to court who are asked to raise their hands, and this Dr. Pei is testifying to not just his opinion, but to their opinion. And in fact, as the state phrased it at times, that he concurred with their opinion. And this is, I think, important as we get to harmlessness in this question, because as sort of the state mentioned, I think earlier in the arguments this morning, there's an argument that we were able to fairly, depending on your take, and of course, I don't know what the juror's take was besides the verdict, but there were aspects of Dr. Pei's opinion and his testimony that we were able to attack, that he was not particularly a PET scan expert, which is what he was testifying to. But the issue with the confrontation violation here is, of course, that as he said, well, there were PET scan experts, and their opinion was that this doesn't show brain damage. And that's really the problem, right? Because we are looking under the confrontation harmlessness analysis of what would be the impact of us being able to cross-examine, or really it says assuming that the damaging potential of cross-examination were fully realized. And what we didn't have in this case was cross-examination of the expert that Dr. Pei was then sort of relying on to say that he's the expert and he has the same opinion. So we weren't able to attack that, and it really allowed the state to insulate any criticism of Dr. Pei's testimony against what we were able to do. And then, of course, the other factor in this is that we then requested to bring our expert back in thorough rebuttal. I mean, first we requested to delay cross-examination so our expert could be there to assist us in aiding, and that was denied. But then we also requested to bring him back in thorough rebuttal to respond to these allegations that were quite critical, that this was a manipulated, or basically that our testimony was somehow deceptive to the jury. And as this court ruled in the previous opinion, saying it is hard to imagine a situation in which the allowance of thorough rebuttal would be more sensible and its denial more arbitrary.
Mr. Perkins?
Yes.
May I ask a question? So there were 3 experts that were in the courtroom, right?
Yes.
Okay, who wasn't in the courtroom that the expert referred to?
I don't know who wasn't in the courtroom. As the expert said, the exchange was, the question was, the people that do PET scans, why aren't they here? And Dr. Pei responded, he is here, one of them is here. So I know that at least one of them, which he referred to, I think, as Dr. Flynn as one of the PET scan experts, was there. There were apparently others that weren't there.
But apparently, there were apparently others. But did your client have the opportunity to cross-examine, to call those witnesses?
We did not have those are two different questions, right? We did not have the opportunity to cross-examine any of them. Or direct examine them? I mean, couldn't you call them as witnesses? We could theoretically call them as witnesses, but the question on testimonial hearsay is a confrontation issue. So the core of the confrontation right is the ability to cross-examine, which is a separate right from the ability to, say, subpoena witnesses in favor of the defense. And that is a question that this court has addressed going as far back as State v. Fisher from 1977, saying that just because a witness is in the courtroom is not sufficient to establish the right to confrontation. They have to actually have been called, because it's a core difference. And that case—
Right, but could your client have called those witnesses?
Theoretically, yes. Although, well, we don't know all of them. Theoretically, they could call them, at least the ones that were there. But
speculatively, we don't even know who wasn't there, right?
Right. Right. And that Dr. Pei is testifying on behalf of. And that Fisher case, which is 222 Can 76, was a pre-Crawford case, but this court has used it in post-Crawford cases, one of which was State v. Miller, 284 Can 682 in 2007. And this is cited in some of the briefing in this case.
Counsel?
Yes.
Sorry, I didn't mean to. Were you done with your citations? Yes. I'm sorry about that. When I read his testimony from the record, Dr. Pei, what facts or data that form the foundation of his own independent opinions did you not have the opportunity to explore? I'm trying to identify specifically what foundational evidence was unavailable for cross-examination. I understand that he testified that others concurred with his opinion, but he arrived at that opinion first. So what data was sort of carved out of these proceedings that you couldn't properly confront through Dr. Pei? Does that make sense?
That does. And I think my answer is the opinion of a PET scan expert.
Well, he is qualified, right? He didn't do PET scans on a daily basis, but he was qualified to review them, was he not?
The district court did find that, and I don't think we objected to it. Although, again, this is in the context of this witness coming in at functionally the last minute with little notice to the defense. And that is, I think, also part of this question, because not only did we not get to cross-examine these, but this is also this last minute notice to the defense sort of context in which they are then bringing in other experts through the testimony of this witness whom we had only had minimal notice about, and in fact was different than the expert that the state had originally indicated would testify.
Right. And so this isn't a situation where maybe an expert is bringing in findings from an autopsy where the person conducting the autopsy isn't available. I guess, is there any subject matter that you can identify from the record that was only sort of bootstrapped in through Dr. Pei?
And the main point is, I think, the consensus that this wasn't just Dr. Pei, that there were other doctors who are bringing this in, which is, as the state mentioned this and discussed this in closing argument as well. They, point out, this isn't just Dr. Pei, this is the neurologists, a group, and they all concur to this.
Right.
So
So he's sort of embellishing his own opinion in that fashion. Is that the argument? That
yes,
it's a credibility bolster in a sense at that point. It's not so much that the subject matter you can't get at because it's not within his expertise. It's that he's unfairly lobbying in these other endorsements.
yes, that is how I'd phrase it, and that it insulates those other endorsements because we have no opportunity to confront those witnesses.
Speaking of opportunity, Mr. Perkins, weren't you given the opportunity to interview or at least to have some discussion with Dr. Pei prior to his cross-examination or even prior to his testimony?
Yes, the district court allowed us time prior to cross-examination to talk to him.
And so weren't some of the inquiry that you're saying you kind of lack the background for, lack the ability to inquire, you at least had the opportunity, and I appreciate it was sprung, your position is it was sprung on you at the last minute, but you did have an opportunity to interview prior to cross-examination so you could at least explore these things off the record with him.
Yes.
And also, are you arguing, you started with your cumulative error framework for the entire errors, but are you saying standing alone, this issue with the confrontation and rebuttal is not harmless? I mean, is that your position, standing alone?
Yes, both standing alone and cumulatively, and of course these are pretty intricate or stacking issues dealing with the same evidence. And that further goes into how the state used this evidence in closing argument, and several of the instances in which the state used as in P17, which was our issue 34 in our original brief dealing with closing argument error. The state used this evidence that they are able to get in, and this expert in a lot of different ways, both to discredit the defense, to discredit our witnesses, and to attack our overall mitigation case. So, some of the instances in which the state argued we have asserted were impermissible comments on credibility, calling these pretty slick, as this court somewhat noted in the previous opinion. The state, compared when the truth comes out and what their doctors say versus the hocus pocus of what our doctors said. Talking about sort of the general scope of this, the state was then arguing that our entire mitigation case was built upon this and then came crashing down like a house of cards. As they said, that it is shameful to try and throw yourselves in a category of individuals who are emotionally disturbed and in some way less because of this sham, which are, I would say impermissible attacks on or statements of opinion. There's also some disparaging of the defense in there, calling it shameful, calling our case a sham. And from there, in closing argument, the state really launched several different attacks. But I think when we sort of look to where the error was here, what is really happening frequently is a misstatement about the law of mitigation, sort of comparing it to an excuse or justification, or even at one point a license to kill. And then disparaging defense counsel or denigrating the concept of mitigation, often based on that erroneous standard there, which goes back to the Clapis 1 opinion that this court talked about, or of this court, where, it was said that, they can argue mitigating isn't mitigating, but they can't say that evidence isn't mitigating as a matter of law. And particularly where I think this comes in was where the is most comparable to Clapis, were the instances comparing the concept that mitigating evidence isn't mitigating because it's not an excuse or justification, which is, I think, where a lot of this sort of falls into. You have, numerous statements that are just, I think, generally disparaging in here, referring to mitigation evidence as dirty laundry, references to abuse excuse or a blame games that, the defense is blaming their parents or in fact trying to blame the jury for an outcome. Then there are statements that have been repeated, saying that our evidence of abuse in our client's childhood here, they ask the jury, is that an insult to children who have been placed in bathtubs until their whole bodies have been burned? Is that an insult to the children who have been beaten and bruised on their whole body by their parents? And then concludes to suggest that gives them a license to kill, which, is, those cases aren't this case, they aren't in evidence. It is denigrating the defense. It is then also suggesting that the standard is a license to kill, which is, inaccurate beyond just the, it needs to be an excuse or not. You also have statements specific to Jonathan in there, that his attempted suicide did not stop him from making that choice that day, which again is, I think, very similar to the statements in Clapis 1 that were improper. You, of course, have, the objection and the facts not in evidence involving the pop, pop, pop comments, which, of course, the court did sustain there, but are still erroneous statements within the spectrum of all of this. And I guess the last point on the closing argument that I would bring up here, although there are numerous statements, and as I'm sure this court will look through thoroughly, as I marked up the closing argument in this case, I got, there was something challenged almost every other page in this opinion, or in those closing arguments. But as they sort of wrapped up with that, the Dr. William Gatlin speech, as they said, and talking about the moral constituency and how, sympathizing with the defense impacts the deceased. And they go, and we look at the defendant and sympathize with him. And when that happens, the defendant usurps the compassion that is justly the victim's and will steal their the victim's moral constituency today with you in the same way that they stole their lives. And I find that with you particularly problematic, that the state was arguing to the jury, not just that sort of the concepts of sympathy or reviewing mitigation evidence is diminishing the victims in some way, but that the jury's determination on the mitigation aspect and if would be injurious to the deceased. And I think that when you look at the way P7, P8, the closing arguments play together, I think it also brings up a difference in what was originally P10, the beyond a reasonable doubt, or that mitigating evidence doesn't need to be proved beyond a reasonable doubt instruction. Yes.
I'm sorry, before you moved into that, I didn't realize that you were done with P8.
My apologies.
Rebuttal. No, that's okay. And I've been waiting to jump back in at a natural point. I don't know if it'll ever come, so I'll just ask, what would Dr. Preston have testified to on Sir rebuttal?
So there were a few different conversations on this. One that came in was sort of a general response to the concept that he had deceptively mitigated the evidence and would not. There's also specific references to that he would testify that the it was a standard 20% reduction of, I think, background noise or scatter that was involved in the case.
Let me be more specific, I guess. What that he had not already addressed in his direct or cross, what was expressed by counsel on the record in terms of a proffer, I guess. I agree. It seems to me, and that I think you touched on it, that the point of calling him back was to say, I didn't do what I did, which was change the orientation and coloration to deceive. Is there more to it, or is that essentially the gravamen of what?
That is the gravamen, and yeah, the only other specific in there is that it would be a standard 20% background reduction is what took place. So that, again, he didn't deceive, he was doing standard procedures.
Thank you.
And so to get back to the aggravating and mitigating instruction that this court has discussed as state law error in Cheever 2 and Gleason 2. One of the things that I think makes this case different than Cheever 2 and Gleason 2, as I read those opinions, is the way the state has contested the pure existence of mitigating evidence in this case, which as I read those opinions, they seem to, in part, find harmlessness in the concept that the state didn't contest the existence of mitigation. So the jury wasn't being pressed to make a sort of evidentiary call to begin with. Whereas in this case, the state expressly did that and extensively did that. And I guess to
Counsel,
yes.
at least one of the jurors had been told by counsel for the defense during jury selection that mitigating evidence in the penalty phase did not have to be proved beyond a reasonable doubt. If that's true, what, if any, effect does that have on the court's analysis of the lack of instruction before the penalty phase, that mitigating evidence did not have to be proved beyond a reasonable doubt?
Well, I would acknowledge that in Cheever 2 and Gleason 2, that was a factor going into the harmless error analysis. There is, of course, a distinction as this was not in the actual instructions given to the jury. And the jury is also, directed to disregard statements by counsel that are inconsistent with the instructions. So I think that's where.
But your position is that there was no instruction, and that itself is the error.
Yes.
So how is that analysis affected by counsel's statement during jury selection that mitigating statements did not have to be proved beyond a reasonable doubt to at least one of the jurors, TW?
And so I think that would, one, like I said, the statements of counsel are not the instructions, and the jury is instructed that. So the instructions actually given to the juror at the penalty phase proceedings did not include that.
So it's irrelevant? So it's irrelevant that it was said?
Well, I think it is relevant to the question, but it's also looking at, what was the law given to the jury. I'd also note that this is, a 2 months later when we're getting to the penalty phase. So I don't think it's particularly a strong inference to pull that at that point, the juror, when they are given instructions that do not include that standard, is going to go back to the statements of counsel during voir dire 2 months ago and add that instruction in, I guess.
Does it decrease the likelihood of confusion to the jurors?
I don't think it really would, because again, they're getting one instruction during voir dire, which is not present during the closing instructions. So I think that could increase confusion, actually, or at least it's hard to tell there.
Thank you.
I guess I can get to some of those further issues on here. So turning to
Before you turn to that,
Yes.
sorry, that I think at one point there might have been some question, but that instruction was in fact requested by Jonathan Carr.
it was in his requested written instructions, which was we objected to the instructions given by the court to the extent they are inconsistent with that at the instructions conference and the pre-instructions conference. And that objection was joined by Reginald Carr.
So it wasn't necessarily discussed at the instructions conference, but it was in the original material submitted.
Yes, we discussed, we have submitted these written instructions. We are objecting consistent with those, and the judge accepted that and let Reginald join Reginald's counsel. Turning to, I guess, state law severance, which is an issue that came up this morning, and also is one of the errors that occurred. We are sort of argued it, I think, two ways here. First, that there is already the guilt phase finding that these cases should have been severed, and as well that if there is independent analysis, that independent analysis should look to what the factors that are already in Kansas case law, but also the individualized finding that is required under our statute that is, the now KSA 2166-17 determination. And the thing I would add, I think, to that analysis, I think there are two factors here that also come into play in looking at statutory severance as it applies to this. The first is the question of how does statutory severance or statutory joinder, which under KSA 223202 applies at the charging stage. How does that play into our death penalty statute, which isn't triggered on the charging, but and is separate from the charging, as in fact the state has argued even in this case and other issues, and is triggering off of the state's filing of a notice of intent to seek a separate penalty proceeding, or seek death and to trigger a separate penalty proceeding. And as I look at it, I struggle a little bit to see how we are getting to joinder to begin with in our sentencing phase when it's triggering off of something separate from the charges, which is where joinder occurs. But I also, as Mr. Evans brought up in several of the motions for severance here, would mention that I think joint sentencing proceedings is inconsistent with our statutory mitigators. Several of them that were brought up in this case, that the defendant was an accomplice in the crime committed by another person and the defendant's participation was relatively minor, or that the defendant acted under extreme distress or under substantial domination of another person. I think to the extent that there is a separate penalty phase analysis factored in is, I think, that we have the legislature's recognition that mitigation through these statutory factors is an adversarial process. And so, those were part of the core of our mitigation case here. And I think those, if there is separate analysis, those factors should come in.
But factually, what your argument for severance wasn't about that, was it? I mean, it's about handcuffs on Reginald. It's about the family dynamic sort of spilling over, or I guess co-defendants' familial circumstance evidence spilling over into Jonathan Carr. Those are the grounds for that have been raised for severance of the penalty phase, right? Or severance in general.
Those are, as I put it, as we look at this from, post-trial, those are our points of error and prejudicial evidence that came in. As we looked at this from sort of why we were asking for severance, we repeatedly stated that we would have to, through these statutory mitigators, prosecute Reginald, and that indeed family members would have, tying into the family circumstances here, that family members would be hesitant to talk about, the role of one brother in dominating the other because of the family situation. The handcuffs was something that we could not have predicted was going to be an error there, but is an after the fact error. And turning to, I guess, what I have labeled as new issue 2, which was the amicus brief filed by the LDF in this case, and raised a Section 5 issue. I know this court ordered the parties to be prepared to answer questions on that. I can address that standard if that is acceptable, or so turning to that argument, which I think is a novel Kansas constitutional argument that was brought up here, we're looking to things that were well established at common law when we look to Section 5 and the inviolate right to a jury trial under the Kansas Constitution. And the thing that I found remarkable when I dug into this issue raised in the amicus is that this standard for jury selection or for exclusion of jurors that was, that they can only be excluded on an opinion from the death penalty that would render them unable to come down to a jury verdict, extended not just in our territorial statutes, but extended all the way through to the 1970 new criminal code. And so this was actually the standard that was employed in every capital case in which someone has ever been executed in Kansas history. And that includes both our original constitutional era or original foundational era when we had an automatic death penalty on a guilty determination, but also our post-1935 cases where we had jury discretion in the imposition of the death penalty. And so, this was the established standard for capital cases for over 100 years in Kansas law. And it's only in this post-1994 context that we have this differentiation, basically applying the Wainwright v. Witt standard as a new standard that is then excluding jurors based on an opinion to sentencing as opposed to an opinion on the guilt finding. I think this ties into sort of our statutory standard already for excluding jurors because of an impartiality, which looks to whether or not they can be impartial or there's impartiality, and the statutory language uses to the substantial rights of the party. And I think comes down to part of these overall questions of, does the state have a substantial right to a death sentence, but two, when the legislature has determined that we are going to be using a discretionary jury sentencing system or a guided discretionary jury sentencing system, does the state have a substantial right to a specific outcome? And I would posit that they don't, that they have a right to a jury verdict on the sentencing issue that is inclusive of the community, and that includes jurors who are against the death penalty.
Or immovably supportive of it as well, under that rationale?
Well, one part of that I would, I guess I would distinguish that in two ways. One, no, we have a separate right of the accused to an impartial jury, which is distinct and the accused's right, and the state does not have the same right as the accused per Section 10 of our Constitution and the Sixth Amendment of the United States Constitution. So there is a sort of a floor and a ceiling, I think, distinction in there.
Mr. Perkins,
Yes.
on that issue, isn't the real question whether or not the juror can follow the law? Because when you say it's discretionary by statute because it's a weighing to see whether or not the aggravating factors, any aggravating factors that have been found against, the mitigators. So there's the discretion. But what you have is a juror who said, and I didn't read all of it, but jurors who said, I don't care what happened, I'm against the death penalty. So aren't they basically saying, I don't care what you tell me. I don't care if I don't care if there aren't any mitigators at all. I'm not going to do that. I'm not going to follow the law.
No, in our weighing process, which includes the aspects of mercy, the jurors are able to determine the weight individually of aggravating circumstances, and they can determine that the state's aggravating circumstances don't carry weight in their view. So I think they are still able to exercise within this guided discretionary framework the concepts of mercy and their role. I think I have actually been able to cover the areas in my outline.
Would you just, Mr. Perkins, would you just comment? I think the overall position on the cumulative error, especially as we accumulate, or if there's errors that we need to accumulate, that it's essentially the overwhelming nature of the existence of aggravators pretty much offsets everything and would not change the outcome. I don't want to forecast Mr. Loudon's position this afternoon, but that was basically his position this morning. And if I've misstated that, Mr. Loudon, you can clarify that in your, but that's basically the position of the state. Do you care to, what's your position on that?
Well, yeah, I would care to comment on that. And my position is, as this court has sort of laid out in the cumulative error standards and in various other ways, the question is not one, whether the evidence was overwhelming, because we're kind of at a analytically separate stage, right? We are weighing aggravating and mitigating evidence. And there was mitigating evidence in this case, substantive mitigating evidence in this case, going everything from, the fact that Jonathan Carr, at the time that these horrible crimes were committed, was 20 years old, that he was less than 2 years over the age at which our Constitution and our statutes recognize as an area of diminished culpability and excluding someone from capital punishment in general. But those characteristics that are discussed with that, transient rashness, proclivity for risk, and the inability to assess consequences, are both present and exacerbated in Jonathan Carr's case through both his family history, his the reality that was presented here, that he grew up in this household where both physical and sexual abuse of children was normal to him and other children, that children were required to inflict and assist with the abuse of others, that he growing up and throughout his youth demonstrated learning deficits, that they demonstrated a delayed developmental history, that he was held back in grades, that he had the academic achievements when he was tested of a second or third grader, that he has genetic predispositions in his family to dissociated thoughts and schizophrenia, as well as other disorders, that he had numerous childhood head traumas, suicide attempts that put him in a coma, that he displayed in his life and to himself these concepts of inability to assess risk and consequences of violent actions. And then, of course, as was sort of present in the issues with P7, P8, and P17, brain damage to the sections of his brain that deal with short-term memory and the ability to assign risk. So that Jonathan Carr is someone who displayed in numerous different levels, showed the transient rashness and an ability to assess consequences that is core to the mitigation of culpability. And so that's the case that this court is looking at. Not just was there overwhelming evidence of heinous crimes, which this court has already said there was overwhelming evidence of, but the jury's balancing there, and most importantly, whether the state can show, and in our cumulative error standard, beyond a reasonable doubt, that the errors in this case did not impact the jury's weighing, which I don't think the state can do in this case. I'm happy to answer other questions, but that's where I was with my prepared remarks.
I don't see any other questions. Thank you, Mr. Perkins. With that, the court will be in recess for 15 minutes. I will call court back to order. At this time, Mr. Loudon, you may present your argument.
Thank you, Chief Justice. David Loudon, Special Appointed Prosecutor for the 18th Judicial District, Sedgwick County, Kansas, appearing with District Attorney Mark Bennett, who is off camera. Like counsel, I will, and as with the other argument, I will start with the umbrella issue here, and it comes down to cumulative error, the state believes. We certainly disagree with counsel and Mr. Carr regarding the number of errors and the quality of those errors. Starting with the penalty phase focus, or excuse me, the reverse Batson error was one of the first issues taken up, and trying to graft that into the penalty phase cumulative error, we think the court should not do that. We understand that Mr. Carr is arguing that he attempted to remove WB as a juror based on his views about the death penalty and mitigation, I believe. He was stopped from doing that by a peremptory challenge by the state, or he was stopped from making a peremptory challenge by the state's argument that this was a Batson issue. This court drew into question that decision by Judge Clark at the time, and we're not here to have qualms with that decision at this point in time, because I do believe that it comes down to the effect of the alleged error on the penalty phase. There is no indication that this would have broadly affected the trial. The notion is that, from counsel, is that somehow, because this person had some views that he didn't necessarily agree with, that somehow those views affected the way he decided the case or his verdict at the penalty phase, meaning he WB. But what we do have here in the record is some evidence that a juror's views doesn't necessarily dictate how that outcome is going to be. The state tried to strike CB from the jury panel, from the jury, and that was objected to through a Batson challenge by the parties. And he ultimately was able to sit on the jury. That person, in the state's mind, the state had tried to strike that juror for cause and with a peremptory strike based upon his views and the state's concern that he would not be able to impose death and that he was death compromised. Judge Clark denied our challenges because of finding that the defense had basically rehabilitated him and extracted from him an opinion that he could set all that aside and make a ruling on the law and the facts of the case. And as you know, that person who the state was worried about ultimately formed part of a unanimous verdict for guilt and for death. So I would ask this court not to use the reverse Batson error as a basis for a cumulative error finding in the penalty phase. As far as other error in the case, on the confrontation issue, I addressed that in the other argument. The state would ask this court to consider the same type of argument regarding the applicability of the confrontation clause to this situation in the penalty phase, and to determine whether, number one, whether that confrontation is a right under Crawford? And two, if so, what is the scope and the applicability of Crawford in a situation where the state is not trying to prove aggravating circumstances through evidence that was not subjected to confrontation, but is instead offering up some evidence that cuts against some of the mitigating evidence and whether that's a permissible purpose. We weren't trying to do a non-statutory aggravating factor. We didn't speak to that. We didn't try to apply it to any of the aggravating factors. This was a situation where we tried to use what we termed, as you know, this wasn't hearsay evidence. It was not offered to prove the truth of the matter asserted. It was used to test the opinions of people, whether those facts that are being elicited were truthful or not truthful. We weren't trying to prove that. And how do we know that? The state didn't argue any of that in its closing in the penalty phase. We didn't use that information. As I previously argued, the other part of that is the information that we were bringing forward didn't create a situation that made Jonathan Carr look like a worse individual. He did that himself on the night of December 14th and the morning of December 15th by his actions against the 5 victims in this case and 4 murder victims in this case. He couldn't look any worse. And it wasn't because of what we did in closing or at the penalty phase. As far as one thing I'd like to point out on that confrontation issue as well, there was no confrontation objection raised at the time. There were a couple of objections raised by Jonathan or Reginald's counsel regarding facts not in evidence, but I don't believe there were any objections to confrontation. And as this court knows, that could possibly be because there was no confrontation right because Crawford came down 2 years later. But be that as it may, it doesn't matter what the reason is. It didn't prevent counsel from making an objection. There was no objection made, and that's the point, is we don't know why there was no objection, no established record, no basis to determine harmless error beyond a reasonable doubt based upon even a confrontation analysis. As far as the related issue with P7 on the expert's opinion, the state would submit that there is a similar analysis regarding harmlessness as provided in the other case. What we had here was one witness who was Dr. Pay, who was cross-examined, a direct exam on other expert opinions. There was an ability to cross-examine him about those, and they did so. And part of that cross-examination was to question how much information Dr. Pay had reviewed with regard to the scans and the cuts and how many were done. And what was revealed was that he hadn't looked at all the information. He had looked at the information that was provided as an exhibit, that Dr. Preston had looked at some other information when reaching his opinion on that. He was also able to present testimony from another expert, Dr. Cunningham, who wasn't quite, he did some neurological, I'm sorry, I can't speak, testing, and he found some abnormalities, and he testified about that too. So it wasn't that Dr. Pay was out on an island, or Preston wasn't on an island with regard to his testimony that Jonathan had a damaged brain. There was some other evidence to support that as well. And again, there was no confrontation objection here. It was objection to other people's testimony, and that could have been on a hearsay basis. So and I'm not saying that because that didn't happen, that there's no way to apply, the current law on confrontation. But I would add, I mean, if this decision, if this argument had happened at a certain point in time before Crawford, we wouldn't be talking about this. What we would be talking about is how Judge Clark made an appropriate ruling when there was an objection to other people's opinion, which I take to mean, probably at the time it would be hearsay, and there was no problem with that. So again, if we're looking at the egregiousness of the error, that certainly isn't an issue, because at the time that was a correct ruling, and there was the ability to call his own witnesses and to challenge that. Instead, he chose not to do that. He had the ability to cross-examine Dr. Preston on that as well, and rather than challenge what those other people may have said, and rightly so. I mean, I don't think any attorney in their right mind would, multiply somebody's opinion times 4 when you know that it's going to get against you. So, but he had the opportunity to cross-examine on those things, and he didn't do that as well. So then that bleeds over into P8 regarding rebuttal. Again, our argument is that it's harmless error beyond a reasonable doubt. For similar reasons, there was a cross-examination on Pay about him not talking to Dr. Preston about his contrary findings, and admittedly, there was a short time to do so. Dr. Pay was a rebuttal witness. Based upon information that came out in court just the day before. The state scrambled to talk to Dr. Pay after Dr. Preston's testimony the day before. So the notion that somehow the timing of this is the state's going to be at fault, I think that belies the reality that until that testimony was on the stand, we didn't have the ability to go get Dr. Pay and have him rebut anything. We didn't know what was going to be said. But be that as it may, there was the opportunity that to cross-examine that, and admit that he hadn't talked to Dr. Preston and that he hadn't reviewed all the scans. And just like I said before, they were able to, for lack of a better word, impeach or undermine Dr. Pay's opinion that Dr. Preston had manipulated something. At the end of the day, with the harmless error standard, if you combine that with the strength of the aggravating factors, and Justice Rosen, I think you adequately and correctly indicated my position on the strength of the evidence being the strength of the mitigators and the quality of the evidence that supported those, not the quantity of that evidence. I think Mr. Perkins, if I understood him correctly, he was trying to move more towards limiting or the limited nature of overwhelming evidence when we're weighing this out. But that's on a scale of guilt. And that's not that. If that's his argument, that would be misunderstanding what I'm saying. Is it was the quality of that evidence and the strength of that evidence supporting the mitigators that showed that underlies why we believe that evidence is harmless, whether any error here is singularly or cumulatively considered. I do want to go back to a question regarding, I think Justice Dandridge had asked me a question in the last one. I just wanted to just make clear when the state law standard on harmlessness, reasonable probability versus beyond a reasonable doubt. I think that's kind of what we were going toward before. I just want to recognize that I do recognize that when we talk about substantial prejudice on a state law level, we are talking about a reasonable probability of prejudice versus the beyond a reasonable doubt standard. And I also do recognize that that would apply to a single error. But when we move into the cumulative error position, we're dealing with a different standard there. So I'm not working under any misunderstanding about what we're talking about here. So to the extent that this court understands my arguments, they're in the context of that understanding. As far as the cross-examination about criminal, or let's see, pardon me, let me just flip to my notes here real quick. On the P17 issue, on the impermissible comment on credibility during closing, the state is, I don't want to go through each one of those. The state has laid those out in its brief and its explanation. As you're aware, in typical case, a defense attorney on appeal is going to point toward some of these comments and use them in isolation. And in isolation, they maybe don't look so good based on a word choice, for instance. But this court's standard of review requires that we look at the context of any comment that is made. And while something may be an artful or very expressive, that's permitted as long as it's done in the context of something that is permissible. And here we would submit, if this court looks through each of those questionable comments in the context that they were made, that this court will find that there was no error. To the extent that this court does find error, we submit that none of those errors raise to the level of being reversible error, that they were harmless error based upon not only the strength of the aggravating factors or the heinousness of the crime. And I don't need to go through that again, but this court knows how bad it is and how bad it was for those victims and the evidence. But we would submit that these comments, they didn't tip the scale in favor of the state's request for death. These comments, they existed there, but they weren't enough to force somebody to go from not voting for death and then voting for death. That wasn't the focus. So in and of themselves, that error is harmless. And that includes the disparaging of defense counsel. Those comments, misstating the law and mitigation, I think is one that Mr. Perkins raised. The facts not in evidence, in particular, that doesn't fall under that explanation I just had. But what it does fall under is there was an immediate objection. There was an immediate response by the court that sustained that objection. There was immediate order to disregard that evidence. Case law is replete with cases that say if those steps are taken, there is no basis for error. And we would submit that there's no evidence the jury disregarded its duty to follow the court's instruction to ignore that piece of evidence. So that can't be factored in.
Counsel, can you address maybe in a little bit more detail your opposing counsel's argument about how closing argument tended to denigrate the mitigation evidence and mischaracterize as a matter of law what mitigation is by sort of labeling it as an excuse or a blame game, things of that nature? Was that a fair representation of what the argument was, or?
I don't think so, Justice Wall. I think that, of course, I mean, there's a continuum of objectionable language versus not objectionable language. This probably falls somewhere on the closer to the side of something that raises your eyebrows when you hear it. But again, that's why I say you have to focus in on the context in which it was said. Obviously there are some things that you can't say that regardless of the context would be improper. But here, I think the overarching theme that the prosecutor used in this was appropriate. The comments were made. I can't get away from that. But in one part of the closing argument, for it's on record volume 75, page 134. The district attorney at the time, Ms. Folston, indicated, and the question is what mitigates punishment, something for the jury to decide. What, and this comes over to 135, what is it that should lessen or alleviate or diminish or decrease the responsibility of Jonathan and Reginald Carr for the punishment that fits this crime that's set forth by the laws of the state of Kansas? She on a few occasions reminded the jury what the law was. It was for them to decide the mitigation. And I think the notion here, or the implied notion, is that somehow the jury wasn't reminded, or they disregarded the instructions which told them to follow the law, and this is what they could make their decision on. This sympathy aspect or lack of sympathy aspect was also, that's not an uncommon thing for somebody to push. The jury was in fact instructed that they could rely on mercy and sympathy in this case. And they had volumes of information concerning their bad childhood, their problems, brain injuries, their alcohol, drug use, lots of things that went into this. So Jonathan Carr, he wasn't harmed by this closing argument that on the basis that they're alleging. Does that answer your question, Justice Wong? Okay. As far as some of the comments regarding the criminal conduct, I think Mr. Perkins, he didn't talk about that a whole lot, but I think he touched on it. To the extent that some of the allegations were subject to an objection or a trial court ruling, I mean, those certainly can't be deemed prosecutorial error. I mean, it would have to be something that's in a closing argument or something of that nature, or just a really bad misstatement of something. But I don't think any of those were the case. Under the Sherman test, this court would first have to find that the comments were beyond the wide latitude permitted. And we briefly talked about that. And then there was a prejudice to the due process rights to a fair trial and beyond a reasonable doubt. Under that standard, I don't think this court can say no reasonable probability that the error contributed to the verdict. If you take those things out, I think is one way to do it, and one way to say it is if we take that closing argument out, or those offensive words, are we left with enough there to say that the outcome would have been the same? And that's what brings me back to the other parts of what the prosecutors were arguing, and what they were arguing was within the bounds of the law. And if you excise even if you excise the alleged improper comments, that we're left with enough the jury could make its decision. To the extent that there's an argument about the cross-examination of some of the witnesses on unadjudicated conduct, or about the jailhouse bragging about the Birchwood victims, or the crude reasoning for raping one of the victims, those things were not offered as truth of the matter asserted. Again, as we argued in the Reginald argument. These things were used to test the knowledge of the people that were testifying on behalf of the defendant on the mitigation aspect of things, where they said Jonathan had, there was times that he had good character that I knew about him. And this was used to challenge that aspect of things. It's important to note that in the course of weighing this out, there were instructions on given individually for each of the defendants. And that's important because they were treated as individuals. No party at the closing argument had suggested that they should be treated together or receive the same fate, except that when you looked at them individually, they both deserved the death penalty in this case. We have nothing to contradict that the jury followed that presumption. I know that notion that they didn't follow the presumption was criticized by the U.S. Supreme Court in the appeal. However, I think their rationale was good. As we know, the jury did follow the presumption. We think the court should make that same kind of finding. Again, I think I mentioned this in the last one. The state's comments were designed to rebut mitigators of good character. There was overwhelming evidence of aggravators. There's nothing in the P17 realm of issues that would require this court to find that the death penalty should be overturned. As far as the severance issue is concerned, I stand by the argument I made in the other case regarding despite the severance ruling in the penalty phase or the guilt phase, the fact remains that the case remained together, and that severance, the determination of whether severance should have occurred can be decided by this court on state law grounds, which is a ruling that it had not made, as we argued to the U.S. Supreme Court, and it was clear, the argument on severance was in the penalty phase was limited to the federal constitution. Now we're coming back on the state law ground. We ask that this court look at that in the context of the penalty phase by itself. Even if this court doesn't do that, for the reasons stated, we submit that the error was harmless for failing to sever. It should be noted that that's going to be under a state law standard, which is less than the Supreme Court standard or the federal standard of beyond a reasonable doubt, going back to the reasonable possibility or probability standard that I just stated a few minutes ago. Under that lesser standard, the state finds it inconceivable that this court could make that lesser finding or make that a finding of reversal based on that lesser standard when we've already met the greater standard at the federal level. We're not by any means saying that this court is bound to blindly follow that, but we think the logic of the court is there, and we think it would be, it's persuasive on how they put it as far as reversal is concerned. As far as another concern or something the court can look at is there's talk about antagonism. There was no antagonistic defense. There was no defense at the penalty stage. It's improper to even think about it or talk about it. It didn't, whatever antagonism there was in the guilt phase, it didn't bleed over into the penalty phase. What's important to note is that while there may have been some evidence that perhaps painted, one brother in a more negative light than the other brother, Jonathan, for instance, saying, I was influenced by Reginald, but the thing is, in the context of all that, it was always a personal, individual decision. Neither brother nor the state at the penalty phase argued or advocated for the death of the other one based upon this evidence that has been contested at this stage of the process. So that also, I think, factors into this notion of severance. With regard to one of the other issues that Mr. Perkins talked about was the state law finding on the instructions on concerning the burden of mitigators. Again, the U.S. Supreme Court had reviewed this on federal grounds and say the instructions were clear about the burden or lack of a burden to prove the mitigators beyond a reasonable doubt. It's obviously something that the defense is doing its best to argue was confusing, but I struggled to agree or even comprehend how this was confusing. It was a decision that was reached in the Gleason case, and that was also reversed by the U.S. Supreme Court, at least on federal grounds. But now we're here to talk about state law grounds. As far as what standard we use, to me, it doesn't matter what standard this is under. You'd have to be searching to manufacture, and I'm not saying manufacture in a bad way, but you would have to be searching to determine error in order to find that somehow these instructions required or allowed the jury to determine that the mitigators had to be proved beyond a reasonable doubt, or that there was any burden whatsoever. How do we know that? We know that because of the arguments that were made or the lack of arguments made at the time of the closing arguments. Regardless of whether there was an objection made or not made on the instructions, the proof's in the pudding. At the closing arguments, neither of the defense attorneys took any time to say, just be sure you know, these aren't beyond a reasonable doubt. And the prosecutor didn't do that either. In fact, they went out of their way as much as they could to say, any one of you could make a decision for mercy. If that sounds like beyond a reasonable doubt, I don't know what to say, but anybody, this could turn on a dime, and it was clear to everybody there that this was the case. Otherwise, I think you would have had some attempt to clarify, and that just simply did not occur. The state would ask that this court make a finding that is on state law that is consistent with the finding of the U.S. Supreme Court. The court was well aware of all the instructions. It even made reference to the instructions in the case when it made its decision, the U.S. Supreme Court. And any notion that this court, that the U.S. Supreme Court didn't have full knowledge of the instructions is belied by their opinion.
Counsel?
Yes.
I'll ask you what I asked Mr. Perkins. If one of the jurors was told during voir dire that the mitigators did not have to be proved beyond a reasonable doubt, is that relevant at all to this confusing analysis or not?
I think that is relevant, probably more relevant than Mr. Perkins would admit. But I can't sit here and say that somehow this happened 2 months previously, that isn't relevant also. But this isn't a situation where I can't remember if the comment was made. I've talked to so many people, but the comment was made that, statements of counsel aren't evidence. Well, this isn't evidence. This is something on the law. And I don't think Mr. Perkins was suggesting that, but he would argue, when it came down to being informed about the law, that wasn't one of the things the court informed them on. So like him, I think it's relevant and noteworthy just as much as it's relevant and noteworthy that none of the parties were arguing about or presenting any confusion to the jury about the level or the burden of proof necessary to prove the mitigators. You know, the
Well, if you
fact that
think
it
it's-
happened 2 months before, I don't think that's any less relevant than making the argument in closing arguments.
Okay, if you think it's relevant, what are we supposed to do with that? How do we analyze that?
I think you factor that into the harmless error analysis in part. Well, on the forefront of things, I mean, I guess it does factor into whether there was, it wouldn't factor it into the error part, I don't believe, because I think you're looking at the instructions on their face and determining whether there was error. I think the harmless aspect of that comes in when you talk about how was it argued, was there any confusion? I think that would factor in at that point in time. Does that answer your question, Justice?
Yes, thank you.
As far as the handcuffs are concerned, I think that was just briefly mentioned, but I think that I think that the handcuffs is, you know, in the grand scheme of things, is largely a red herring. Just like some of the comments that, you know, can be construed, or the uncharged conduct, or the, you know, the police reports, or some of that stuff. You know, the notion that somehow that was the turning point or contributed to something to make Jonathan look worse because his brother was in handcuffs. Number one, it actually makes him look better because he's not in handcuffs. Number two, the notion that that was the tipping point when these people realized, the jury realized, oh my gosh, this guy's dangerous and he should be in handcuffs. That's not the tipping point. We're out of the guilt phase. I've always questioned whether that makes a difference even in the guilt phase, but it certainly doesn't make a difference in the penalty phase as far as harm is concerned. With regard to, you know, I'll open myself up to the NAACP, their issue, the LDF arguments. As this court knows, based upon my objection to them being able to do oral argument in the case, because this issue was raised 30 days ago or so, without being briefed, and they did so in an amicus brief where they really shouldn't be raising new issues on their own that haven't been briefed or argued. We would oppose any consideration of this issue. I do understand that this court can take up unassigned error. And so to that extent, I can offer some comments regarding this beyond that. This concerns Section 5 of the Kansas Constitution Bill of Rights that states the right to trial by jury shall be inviolate. The defendant's arguing that this is the right to jury trial is a unique fundamental interest expressly protected by the Kansas Constitution. The jury trial right in Section 5 is distinct from and broader than the rights protected by the 6th and 14th Amendment. So the argument goes at this time that the use of the death qualification in modern bifurcated capital trials with non-mandatory death sentences violates Section 5. Again, these are his arguments. The death qualification's common law rationale applied only to a form of capital trial no longer in use. That the pre-1859 common law provides no justification for death qualifying jurors in modern bifurcated capital trials. And death qualification infringes on Section 5 because it skews jury pools and disproportionately excludes Black jurors. Section 5 doesn't protect his right to rights at this point in time. It protects the right to have facts determined by a jury, but not all the details of how a jury is formed. How do we know this? The U.S. Supreme Court has talked about similar language in the Seventh Amendment, that the right to trial by jury shall be preserved in suits at common law. And in the Callgrove v. Batten case, 413 U.S. 149, it's a 1973 case, the court stated, I quote, "Our decisions have defined the jury right preserved in cases covered by the amendment as the substance of the common law right of trial by jury, as distinguished from mere matters of form and procedure. The amendment therefore does not bind the federal courts to the exact procedural incidents or details of jury trial according to the common law in 1791. That's the essence of the state's argument, in part, is that we're not stuck with this proposition that we can't have a jury trial because there was none in place at the time, and that this is somehow bad for Kansas and not appropriate under the Kansas Constitution. As far as the death qualification is concerned, I heard Mr. Perkins indicate that somehow we should be accepting of jurors who indicate that they aren't going to follow the law. That was not a proposition that was okay in 1859 at the forming of our Constitution, and it's not okay now. The law remains the same. If a juror indicates that they are incapable of following the law, they don't get to serve. It doesn't matter whether they're for the state or against the state. The notion that a juror can say that, and then we hope that they can somehow, they're going to be put there because they can do mercy. We have rules against that. It's similar to jury nullification. We don't permit people to come in and not follow the law. Now, they can do that on their own accord, but they're not going to be instructed in Kansas that they can ignore the law and not follow the law. What is the purpose of any jury instruction if not to inform what the law is? This would be that's a renegade behavior that would cause and wreak havoc on our justice system if we couldn't trust that the jury was following the law. Here, the benefit the defendant had was the jury was instructed on mercy, that they could find mercy. And it only took one of them to do that. So whatever outcome Mr. Perkins or Mr. Carr is looking for, he's getting it by the way that we have structured our rules and statutes on the death penalty phase.
But what do you say, counsel, to Mr. Perkins' argument that the juror is following the law if mercy outpaces everything?
Well, if he does that, again, you have to reach a starting point that what occurred, and the people that are getting struck are people who say, I don't care what evidence is there, I'm not going to vote for death. The state has a right to a fair trial as well. And the notion that that somehow that juror can be on the panel, it really doesn't, if the outcome is determined before we even start, what's the purpose of going through the trial itself, as on the penalty phase, at least.
Counsel, Mr. Loudon, if I understand your previous argument and your citation to the United States Supreme Court decision to mean that the legislature can regulate the process of jury selection or qualifications without implicating Section 5, that there's a sort of bright line between legislation that regulates the process of putting together a jury as opposed to a substantive right to have your matter decided by a jury? Is that the argument that you're making, and that therefore the qualification standards in the statute don't implicate Section 5?
I think that's accurate. As far as his or LDF's claim regarding the death qualification disproportionately excluding minorities, again, this is borders on being the policy type arguments that we leave to the legislature. We don't have any proof at this juncture that about the minority makeup of all the jurors, the veneer. We pared it down from, I can't remember what the top number was, but we pared it down to 60 and then started allowing for strikes. What we do know is there were 3 black jurors that were in that veneer of 60. There was another Hispanic, but that's all we know as far as what was brought out on the record. 2 of those jurors, black jurors, made it on, as this court knows from some of the arguments, one that we tried to strike, one that they tried to strike. We were prohibited from striking the Hispanic juror. Or no, we were allowed to strike, I'm sorry. So there were two black men, 5 women, and 5 white men that were on the jury, the actual jury panel. But that doesn't seem to, those hard facts don't seem to be the proper scope of review by this court, because what they're claiming is, the death qualification, and that includes everybody who turned in a jury questionnaire and how people were off. We don't have any evidence of that. We're just shooting into the air at this point in time. So, in addition to the other reasons why I asked that this court not take up this issue, I would ask that this court to reject this issue as well, because we don't have anything to base this on other than some studies and whatnot. And that doesn't prove that somehow Section 5 would bar the process we have in place. With that, Your Honors, as with the other case, I would ask this court to look at each alleged error in this case individually and not as a concept or as a whole. And I know this court will do that, but find that based upon the overwhelming evidence to support these aggravators and the heinous, atrocious, and cruel nature of these crimes, 3 hours of torture. This wasn't somebody who did a drive-by and kill 4 people. And I'm not saying that that's great, but 3 hours of mental, sexual, physical torture, sexual abuse, ending with the execution of 4 people and the attempted execution on a 5th. That is what drives the death penalty in this case in and above anything that could have been, that was raised in mitigation in this case. The defendant, Jonathan Carr, was able to present his case as fully as he could, and nothing that was omitted, and it's very little, could have affected that calculus. We would ask that you affirm the death penalty in this case against Jonathan Carr.
Thank you, Mr. Loudon. Mr. Perkins, you reserve 5 minutes.
Thank you. I only have a few points that I wrote down in my notes to respond to. One of which might be incidental at this point, but just on the timing of the rebuttal, Dr. Pay, Dr. Preston. I have in my notes that Dr. Preston testified in volume 69, which was November 6th. And Dr. Pay was, when he was testifying, that was in volume 75 and on November 13th. So it wasn't a next, they just found out about it and then found their expert the next day, at least according to my notes. I know the record in this case is massive and overwhelming, and I'm sure someone will confirm whether I'm right on that. The other point, which is also probably incidental, but just because the handcuffs came up again, the thing I've always logically struggled with is his brother having handcuffs on during the trial, during the sentencing phase, can be both prejudicial to Jonathan and prejudicial to Reginald, although he invited that error, and also relatively less prejudicial to Jonathan. So I don't get the distinction that it's one or the other, and also to the extent that it somehow was, is said to be beneficial, it's almost, looking at things outside of the evidence to begin with. But again, that's, I think, incidental. And on the Section 5 discussion, the one thing that I come back to, looking at the Wyandotte Convention and the, Kansas, where it was at a constitutional point, and this court, I'm sure, has looked at the Wyandotte Convention more than anyone else or any group else. But that concepts like the fugitive slave law were heavily debated and discussed, and there was a concept that the jury was a check on governmental authority and authorizing punishment, including in those contexts. And the last thing is on the aggravating and mitigating issue. The one thing, there are arguments that the instructions were adequately clear, and I heard Mr. Loudon talk about how no one talked about the standard during closing arguments, as, I think he says that means that no one was confused. I would have looked to that if someone had said that as evidence that, there wasn't any confusion there, but the fact that no one talks about what the standard is, I think leaves open a question of confusion. I also look, I think there is an argument that was in the SCOTUS opinion that basically we talk about proving beyond a reasonable doubt, aggravators and mitigators found to exist, so somehow there's like a textual distinction there that wouldn't get the jury confused. But when I look to instruction 10 in this case, and in the language that this court already found erroneous in issue P13, there's a reference to, if one or more jurors is not persuaded beyond a reasonable doubt that aggravating circumstances exist, or that those found to exist do not outweigh mitigating circumstances. So I think separate from the other cases, there's a little bit more confusion on that in the way these instructions were written. But in some, I think the errors in this case are numerous and severe. They impact everything from having a jury that was composed in violation of the legal right in Kansas to peremptory challenges, to denials of our ability to present a mitigation case, and let alone the severance issues. There might be a desire to argue that a different jury in the context of a fair sentencing trial could still return a verdict of death. But that's not the test before this court. The test before this court is whether the state can show beyond a reasonable doubt that the death verdict actually rendered in this trial was surely unattributable to the errors. And it is not in this case. And we ask that you vacate the death sentence and remand the case for further proceedings.
Thank you to both counsel for your arguments today. The court will take this matter under advisement and be in recess until 9 a.m. tomorrow morning.